Alternative defendants, where the plaintiff is uncertain against who of several persons he is entitled to relief, he may join any or all of them as defendants in the alternative, although a right to relief against one may be inconsistent with a right to relief against the other. An example of this would be a victim or an injured person in an accident between two common carriers. So that injured person may file a case against all of the defendants in the alternative, like the driver of the common carrier that he is in, the driver of the other vehicle, the owner of the common carrier that he is in, and the owner of the common carrier of the other vehicle. So that's joining any or all of them as defendants in the alternative, although a right to relief against one may be inconsistent with the right of relief against the other. This is consistent with Rule 8, Section 2 of the Rules of Court, which provides that a party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. When two or more statements are made in the alternative, and one of them, if made independently, would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. If the plaintiff has alternative causes of action, at least one of the alternative causes of action must be adequately stated by the plaintiff with the same test as that used to determine the sufficiency of a cause of action. So the familiar test for determining whether a complaint did or did not state a cause of action against the defendants is whether or not, admitting hypothetically the truth of the allegations of fact made in the complaint, a judge may validly grant the relief demanded in the complaint. In determining the existence of a cause of action, only the statements in the complaint may properly be considered. What if there is an insufficiency of joined causes of action against alternative defendants? The rules provide that when two or more statements are made in the alternative, and one of them, if made independently, would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. The alternative defendant, against whom a cause of action is insufficiently alleged, may then pursue his or her remedy, such as to dismiss the case. However, the remaining cause of action that is sufficient will not be dismissed.